right? Is this a little more like this? Party peoples of the interwebs, Viva Fry, former Montreal litigator turned current Florida rumbler. I'm on a boat. It happens to be a dingy little paddle boat, but I'm on a boat in a lake, and it's beautiful, enjoying the sounds of nature and the solitude and quietness that comes from not being surrounded by family and whining dogs. Pudge is driving me crazy. All right, people, vlog time, because the Supreme Court has now issued 2 additional rulings. Recently, yesterday, it's Saturday now, they have not yet issued the ruling on immunity, but they issued the ruling on Chevron that people were waiting for, that was favorable to not having as much deference to the administrative state and administrative bodies to enact their own rules, interpret their own rules, and basically run independent from government. So the Chevron decision came down, and it was a favorable one. We'll talk about it tomorrow night during the Viva Barnes Law Extravaganza on Sunday. The other case that came down from SCOTUS was the Fisher case. And that was the case which was supposed to adjudicate on limit the interpretation of the obstruction charges that were brought against many of the January 6ers, many of whom were convicted under this interpretation of obstruction statutes, which arguably, but now confirmed by the Supreme Court, went far beyond the initial intent and purpose of the obstruction charge as drafted. 6-3 decision. And more interesting than the majority decision is the dissenting opinion drafted by Amy Coney Barrett. People were complaining that there's a 6-3 alignment in terms of conservatives versus liberals on the Supreme Court. Nope. I think it's pretty evenly split. 3 conservatives, 3 liberals, and 3 institutionalists. And Amy Coney Barrett is proving herself to be an institutionalist, deference to government. If the government drafted the law like that, well, then we have no position interpreting that law. The obstruction charge, I'll read it for you because it's worth reading. The obstruction charge as drafted, and then we'll get into the case. It says, whoever corruptly, paragraph 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or paragraph 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. That is the Section 1512 obstruction charge that was brought against many of the January 6 defendants, and many of them were convicted under that charge. It was an Enron era provision of law that was added, which was intended to prevent people from destroying evidence and documents or impairing proceedings by virtue of obstruction of documents that were in their possession. It was intended to be destruction, altering, or otherwise tampering with evidence. It was interpreted, at least according to the prosecution in the January 6 cases, anybody protesting who impeded a government proceeding was corruptly obstructing justice, obstructing official proceedings, government proceedings. It was given an interpretation that was so wildly beyond what it was intended to cover that it went to the Supreme Court and got reversed. And the issue here, by the way, you have to understand, it's gotten reversed. The convictions will get overturned. A number of these cases are going to be sent back to the lower courts for remand, for adjudication in accordance with this opinion, with this order. Understand that people were prosecuted under this provision of law because the prosecution, the government, was not looking for justice. It was looking for judicial harassment. You have to understand, a prosecutor's job is not to seek convictions. It's to seek justice. And what we saw in the January 6 persecution were prosecutors, politically motivated, partisan hack prosecutors, not looking for justice, looking for any way to exact persecution against their ideological adversaries by giving unreasonable interpretations to provisions of law to manufacture serious charges with serious prison terms if convicted. And they were by and large all convicted because they're being convicted in the politically biased hack court system that is DC. A prosecutor's job is not to seek conviction, it's to seek justice. And what we've witnessed here were prosecutors seeking injustice, political persecutions, interpret the law in any way that would allow you to tack on additional severe charges to all of these peaceful and some not peaceful January 6 protesters. So that's one caveat. The process is the punishment is the other caveat. All right, now we are what? We're 3 years, January 6, 2021, 3.5 years out of January 6. People's lives have been ruined. People have been locked away in pretrial detention. Jan 6ers have taken their own lives because of this political persecution. So that there is some justice at the end of the day in a 6-3 decision is not justice at all. And I have been saying this for a little while. In the world of tyranny, justice is merely a cessation of the injustice. So there can be no justice for those who have already suffered the injustice of this malicious prosecution. But some people get to say, I told you so. The decision came down 6-3. The majority decision is the only reasonable interpretation of this law. The idea being that this subparagraph 2, whoever corruptly alters, destroys, mutilates, or conceals records or documents, yada, 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 with the intent to impair the object's integrity or availability for use in an official proceeding, and then reads that subparagraph 2 should be even broader than subparagraph 1, the argument is the right one. If subparagraph 2 or otherwise can mean anything and is not delineated by subparagraph 1, if subparagraph 2 is a catch-all that eats up subparagraph 1, you never needed subparagraph 1 in the first place. You could have just said whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so. You didn't need the limitations or the examples set out in subparagraph 1. And that is basically what the majority comes to. When you read the dissenting opinion, I'll read it in a second. Page 8 of this, Fisher versus the United States. If, as the government asserts, C2 covers, quote, all forms of obstructive conduct beyond subsection 1512C1, focus on evidence impairment, brief for the United States, there would have been scant reason for Congress to provide any specific examples at all. The sweep of subsection C2 would consume C1, leaving that narrower provision with no work to do. Indeed, subsection C1 would be an elaborate pump fake, a list of 4 types of highly particularized conduct performed with respect to a record, document, or object, and, quote, with the intent to impair the object's integrity or availability for use in an official proceeding, end quote, followed in the very next subsection, in the same sentence no less, by a superseding prohibition on all means of obstructing, influencing, or impeding any official proceeding. Construing section 1512 in such a way gets the, quote, familiar, end quote, analysis we apply to these types of statutes, quote, exactly backwards, end quote, eliminating specific terms because of broad language that follows them, rather than limiting the broad language in light of the narrower terms that precede it. That is the only way to interpret that section, especially given the fact that it was drafted in the wake of the Enron scandal, and they wanted to cover other methods of obstructing or impairing evidence, availability of evidence that they might not have thought of in subparagraph 1. So you can talk about destruction, falsification. You could also contemplate manufacturing evidence that might obstruct an official proceeding, which was not contemplated in subsection 1, but which might be necessary to cover as a more specific interpretation of subsection 2, which needs to be limited by subsection 1. What's amazing is you go to Barrett's dissent, and I'll just read the last page of it. And basically, Barrett, when we're talking about institutionalists, let me just back up here so we don't get, hold on, there's a bush in front of us. When we talk about Barrett being an institutionalist and just deferring to the powers of government, what she basically says is, well, that's how government drafted it, and we have no reason to interpret anything. As if there's no principle of canons of interpretation of law, as if there's no principle of, in Quebec, we have an expression, a legal expression. It's called le législateur ne parle pas pour ne rien dire. I think I might have screwed it up. The legislator does not speak to say nothing. So when the legislator gives an initial paragraph with examples and then gives a subsection, you have to read that in the context of how it was drafted. If subsection 2 consumes subparagraph 1, then the legislator spoke to say nothing in that subparagraph 1 because it's all encompassed and eaten up by section 2. This is what Amy Coney Barrett says in the dissenting opinion on page 15. The court also emphasizes C2's 20-year maximum penalty, but it simultaneously, quote, glosses over the absence of any prescribed minimum, end quote. Here we go. Quote, Congress presumably enacts laws with high maximums and no minimums when it thinks the prohibited conduct may run the gamut from major to minor. Indeed, given the breadth of its terms, C2 naturally encompasses actions that range in severity. Congress presumably trusted district courts to impose sentences commensurate with the defendant's particular conduct. Listen to this, though. There is no getting around it. Section 1512C2 is an expansive statute, yet Congress, not this court, weighs the, quote, pros and cons of whether a statute should sweep broadly or narrowly, end quote. Once Congress has set the outer bounds of liability, the executive branch has the discretion to select particular cases to prosecute within those boundaries. By atextually narrowing Section 1512C2, the court has failed to respect the prerogatives of the political branches. I respectfully dissent. Wrong. When you interpret laws, you have to interpret laws with the context in which they were enacted, interpreting them in light of the other provisions of the law in order to give those other provisions of law meaning and effect. And Amy Coney Barrett and the other two justices' interpretation of Section 15C2 effectively denies C1 of any meaning whatsoever. So some small justice at the end of the day. Robert Barnes, my partner in law on our Sunday show and vivabarneslaw.locals.com community, is rightly giving himself a pat on the back by saying he was right about Amy Coney Barrett. And we're seeing it in real time now. Yep, that's what the government said, and therefore we have no reason to interpret an otherwise potentially vague or ambiguous provision or give it a meaning that denies another provision of law a meaning. Very happy to do it, she is. 6-3 decision, so finally some justice. Now we're going to go see how this impacts all of the pending charges against some of the Jan 6ers and some of the convictions against the Jan 6ers. But alas, the one that we are waiting for, that has yet to come out, is the immunity case. That should be coming out next week, possibly on Monday, and that is going to be whether or not President Trump benefits from presidential immunity and the scope and extent of any presidential immunity. We'll see. If you like what I do, you know what to do. Make sure that you are subscribed, that you have notifications turned on. Share my channel, share my content with someone who you think might like it, and share it with someone who you think would not like it, because they are the ones who need to have their eyes opened. With that said, get outside, exercise, sunlight if you can get any. Up in Canada, we don't have as much sunlight as in Florida. I miss the sunlight. Talk to people in real life, and now you know your vlog. Peace out, peeps. Booyah!
Charlie, you ever play roulette?
On occasion.
Well, let me give you a word of advice. Always bet on Barnes.